In this video I want to take a look at a common enough question, and that is when the conduct of an employee in the workplace is so bad that it borders on or becomes a criminal matter. This creates a huge problem for the employer, especially having regard to a High Court case there last year involving the ESB and an employee who was alleged to have been on the take. So there is a particular timing problem that an employer needs to be aware of, and that's what I'm talking about in this video. I'm here at the River Boyne, and on the right hand side as we look now is County Meath, and on the left hand side is County Kildare. I'm at, I think it's Ballybogan or Tiercrohan, Clonard, but this is the bridge. Oh my God, there's swans down there, at the far end there. Some swans enjoying a Sunday morning. Anyway, this is the River Boyne, and I'm heading to two other points of the River Boyne. But this video, as I say, I'm just talking about that problem for the employer, where the conduct of the employee is so egregious that it's, when should you report it to the Gardaí? And it's very, very important that you get this right. If not, you can be stuck. When misconduct in the workplace is of such a serious nature that it potentially is a crime, employers need to be very careful with how they deal with it. The advice is the employers should deal with it through disciplinary procedures first, before reporting anything to the Gardaí. This is the case except where there is an immediate risk to the safety of the organisation and its employees. Timing is vitally important in this situation, and the reason for that is because if you report it to the Gardaí and a criminal investigation gets underway, then you really don't know how long it's going to take, and your hands are tied in terms of dealing with the employee. So if you report an issue such as theft, fraud, violence or assault at work, before you commence a disciplinary investigation, you are putting the cart before the horse. Any employment lawyer will advise their client not to cooperate, invoking their right to silence in what has been reported to the Gardaí as a criminal matter. This was the problem in a case earlier this year in the High Court. It was the ESB, Electricity Supply Board versus Kieran Sharkey. Sharkey was under criminal investigation for bribery and corruption following allegations from two developers in 2022 that ESB employees were demanding cash payments to expedite work for them. After notifying Gardaí of the allegations, ESB then wrote to the defendant asking him whether he had substantively engaged in the behaviour that was the subject of the Garda investigation. The plaintiff, the ESB, said the defendant was directed, that's Kieran Sharkey, was directed to comply with his formal instruction in connection with his employment. ESB wanted the judge to rule that it could summarily dismiss Sharkey for refusing to follow a reasonable request in line with his contractual obligations. And under the Unfair Dismissals Act 1977, workplace investigations and disciplinary hearings, employees cannot automatically rely on a legal right to refuse to speak or explain themselves or their behaviour. The Sharkey case, however, was interesting in relation to the employee evoking the right to silence. There haven't been many of these over the years, and the judge ruled that the defendant was entitled to refuse to comply with ESB's direction to answer questions until the concurrent criminal investigation was at an end. So the conclusion is that if you jump in and report too quickly a possible criminal offence to the Gardaí, you could be stuck with an employee that you no longer have any trust and confidence in before you can officially dismiss them, because you may be obliged to wait until the outcome of the criminal investigation by the Gardaí, which can go on for a long time. This High Court ruling in ESB versus Sharkey confirms that an employee can invoke their right to silence while criminal proceedings are hanging over them. It can take quite some time for criminal investigation to be conducted or concluded, and for the DPP to decide to take a case or not. And meanwhile, the employer is stuck with the employee that he has no longer has confidence in. So their timing is important when there is misconduct in the workplace that could essentially cross over into a criminal matter. Hope you find the video useful. If you do, I'd appreciate if you hit the thumbs up button down below. Thank you very much.